Welcome to the Probate Nation. My name is Richard Ruddy and I'm the host of the show tonight. People are living longer thanks to good health care and healthy lifestyles. But as we age, not everyone remains as sharp as they were earlier in their life. Frequently a loved one, a son or a daughter, is called upon to take on the responsibility of helping an elderly parent or family member with financial and medical decisions. Execution of highly recommended legal documents in advance can allow you to provide that help without the need for court intervention or oversight. But not everyone executes those documents in advance. And when the time comes for you to help that loved one with those decisions, it may be too late to put those legal documents in place. If that turns out to be the case, you may need to get appointed to serve as the conservator and guardian of that loved one, and in the process begin the living probate train ride. Our program tonight delves into the delicate conversation that many are having within the family and with an elderly family member about this decision-making ability that ends with the question, how does one acquire the legal authority to help that aged loved one make financial and medical decisions they can no longer make on their own? Our show tonight will look at that process in Prince William County to be appointed the conservator and guardian of an elderly adult with financial resources, from petitioning the court to medical evaluations to the independent legal investigation by a court-appointed guardian ad litem, to the court hearing, and to the probate office and ongoing oversight by and reporting to the Commissioner of Accounts and others of all that you do until the conservatorship ends, and some common problems and pitfalls that often arise along this living probate train ride. With us tonight are two elder law attorneys to guide us through the process in Prince William County. Barbara Lloyd Kessinger is a native Virginian and a law school graduate of George Mason University. She practices law at Lloyd's Law PLLC in Haymarket, where she focuses on estate planning, special needs law, guardianship and conservatorship, elder law, and estate administration. Barbara is a member of the Virginia Academy of Elder Law Attorneys, is certified by the Supreme Court as a guardian ad litem for incapacitated adults, and receives GAL appointments in Prince William County and Loudoun County. Also joining us is Elizabeth Monroe Von Keller, a graduate from the New England School of Law, and has been practicing in private law since 1990. She practices law with her husband at the Von Keller Law Firm, located in Manassas, where she limits her practice to elder law, estate planning, Medicaid and long-term care planning, adult guardianship, and probate estate administration. She is also certified by the Supreme Court of Virginia as a guardian ad litem for incapacitated adults and receives GAL appointments in Prince William County. A member of Virginia and local bar associations, as well as the National Association of Elder Law Attorneys. Please welcome Barbara Kessinger and Beth Von Keller. Welcome, ladies.
Hi, Richard.
Thanks
Hi.
for joining us today. You know, the process, we talked about, really begins with a discussion about some of those basic legal documents that, if you execute in advance of incapacity, can actually, mitigate the need to go to court. Can you tell us a little bit, Barbara, about those documents that people should think about executing?
Sure. Well, whilst one still has the capacity to do so, you should definitely execute a written advance medical directive and a HIPAA authorization. An advanced medical directive is also known as a living will, and that enables you to set forth your health care wishes and to appoint a agent and alternate agents to make decisions for you if you're unable to make medical decisions for yourself, and also to authorize organ donation if that's desired. And a HIPAA authorization would enable certain named individuals to obtain copies of your medical records as well. And you also may want to have a discussion with your physician about a DNR, or do not resuscitate order, if that's your wishes. Another document that's very important while you still have capacity would be a durable property power of attorney. That should be very comprehensive, should have multiple different provisions in there to address various situations that may arise in the future, as well as you may want to consider executing, creating or establishing certain trusts, revocable or irrevocable trusts, or establishing a special needs trust if that would be appropriate. So these are some of the documents, while you still have capacity, you should definitely consider.
Okay, well, those are good things to do, but Beth, a lot of people don't do that.
Oh, that's for sure.
And it's unfortunate. And so what do we do then at that point to fill the gaps with what people haven't done in planning for incapacity? What are the things we can do?
Well, unfortunately, Richard, what we end up doing is having to go to court.
Okay.
And typically, that's more costly than it would have been if people had just executed the documents that Barbara was just referring to. But there is a process that the law allows for filing to be appointed by the court as the fiduciary guardian and or conservator for your elderly loved one parent.
Okay.
The guardian would make the medical decisions that Barbara was just referring to, and the conservator would handle the financial matters that they could have handled under the power of attorney or a trust had they had one.
Okay. So there is a, as we often refer to, these are the legal proceedings of last resort that
Yes.
we end up having to go to when we have not planned in advance. So let's talk a little bit about the process. If we have to go to court, there is a process and to obtain guardianship and conservatorship. So one of the first issues that comes up in that sort of discussion is bonding. So, Barbara, talk a little bit about bonding and how it fits into this discussion.
Well, with a guardianship, typically a bond will be without surety. So bonding's not really too much of a concern. Without surety just means there's not going to be any secured property involved with that bond. With a conservatorship, however, it's a whole different process. There will be a secured bond.
Okay.
Okay.
So, so for the conservatorships, we do have to get, though, a bond with surety.
Yes.
Okay. So that's one of the first things we have to ask people is make sure they can actually pass the test to
Exactly.
get bonded. Okay. Once we get past that, let's talk about the next thing we have to do is we have to prepare some document called a petition.
Correct.
Tell me a little bit about that. What is it that we're doing with that?
Well, there's the Virginia Code that allows us to do this process, sets out what has to be in the petition, and it's very specific, and some of the information is what the court refers to as jurisdictional. If you don't have it in there and you don't get it right, the court doesn't even have jurisdiction to do what it is you want the court to do. Okay. But this would be where you would talk about who the person is that needs the guardian or conservator, who the petitioner is, who the family members are, what's wrong with the individual that requires them to have a guardian or conservator appointed.
Okay. Now, when we file that petition, Barbara, do we have to have a medical evaluation to accompany that, don't we?
We do. That's required by statute, and typically that is filed with the petition. It must be filed under seal, and we also have to file under seal a private addendum that contains the Social Security number for the respondent. Respondent's a person that we believe is incapacitated.
So at least we do try to protect that information from the public's view.
Yes.
That's a very good thing. So we file the petition. There's another thing a lot of folks don't understand. They're applying to be a guardian, and yet there's this thing called a guardian ad litem that gets appointed. What's the role of the guardian ad litem?
The guardian ad litem is an attorney who is appointed by the court specifically to advise this respondent, which is the allegedly incapacitated person, of what their rights are under Virginia law. And they are numerous because, as you can imagine, we're taking away somebody's ability to make decisions for themselves. And every adult is presumed to have that capacity. So they have a number of rights, and including the right to a jury trial if they so desire. So that the role of the guardian ad litem is to advise the person of those rights, let the court know if the person has any objection, file a report that's required by statute.
Okay. So that process of getting someone appointed occurs in connection with the petition that's filed with the court. So we work through that process. We've got a GAO who makes a report to the court. A court hearing is established. How does that process work in Prince William? When do you actually set your hearing up, and what happens at the hearing?
Well, you file a precipice to get your case on the docket. And that's usually when we file the petition too, we file an order for the GAL to be appointed. We do have to prepare those orders in Prince William County ourselves. And once it's set for the docket, we want to make sure that the notice requirements are met, which are also statutory and depends on specific provisions that are included in your petition as to what those notice requirements might be. But for a simple petition, we're talking 7 days notice to people who must receive notice, as the statute provides, and just reasonable advance notice for the respondent also.
So the hearings are on a Friday,
Yes.
usually at 10 o'clock in Prince William?
Yes.
Okay, so your precipice establishes that so everybody knows when to show up. A lot of times in the guardianship, we'll have somebody called a standby guardian. Okay, does that person have to show up for the hearing?
No, that person does not have to show up in Prince William County.
So who does need to show up for the hearing then, besides the lawyer?
The petitioner, obviously.
The petitioner.
And if the petitioner is not the proposed guardian and proposed conservator, then that individual or those individuals need to be there. The respondent needs to show up unless it would be detrimental to the respondent's health care and safety. And in that case, the respondent would be excused from the hearing. And then the guardian ad litem attorney has to appear for the hearing as well.
Okay.
Any other attorneys involved in the case would be there.
Okay, so we get to the hearing. The court hears it generally in uncontested matters. Those generally go fairly quickly. The court enters an order that is much more complicated than people realize as far as things it needs to cover. So you walk out of the courtroom with your court order, okay, in hand. Are you now empowered to act?
Not quite yet.
Not quite yet, so we're not quite done.
No,
What do we
not
have to
quite
do
done.
next?
We have to have an appointment with the probate clerk to take an oath to perform the duties that the court has just appointed you to perform. So this is where the bond would come in. Whoever is providing the surety bond would typically meet you at the clerk's office. In Prince William, you do have to have an appointment. Some courts allow you to just take your order and after the court appearance and go to the clerk's office and take a seat and they'll
Sure.
see you. But we now have to have an appointment in advance, and we can try to set it for the same day. Oftentimes that's not possible, so it might require another visit back to the courthouse to take the oath and get your official, what's called certificate of qualification that has the clerk's seal on it that says, now you're official.
Okay, so so we got another extra step. We have that order, but it's not the end of the program. We go down to the probate office, hopefully with an appointment. We meet the bonding representative there and get ourselves squared away and get sworn in. What do we get to show that we're in charge now as a conservator or as an executor? What does the probate office give us?
Well, you will get a certified copy of your order, and you can always obtain more certified copies of the complete order if they're needed. And then the letters of qualification that Beth was talking about. If it's a guardianship, there's a simple 4-page letter. It's a 3-page letter, actually, from the Department of Social Services with an attachment that shows when you're to file your guardian reports. You will get a sample guardian report with a conservatorship. You will get sample inventory form and a sample accounting form, as well as a much more detailed set of instructions.
So that's for our viewers. We're going to show on the screen the first page of these documents. One is the instructions and duties of a conservator as prepared by the Commissioner of Accounts in Prince William County. And this is a detailed document that goes through a whole host of things that you have to do from the Commissioner of Accounts standpoint. But this is the ongoing oversight as far as what you do with the money from the time you take over until the conservatorship ends. In addition, as Barbara referred, there is a letter which details your reporting requirements to social services. And they're going to keep track as well on an annual basis about what you're doing, and you have obligations to report to them as well. These particular documents will be posted on the Probate Nation website in their entirety for folks who want to look at those. This whole process, without doubt, begs, to point out that you need a lawyer to help you through that process. And of course, there's a cost associated with that. We have a lawyer who's the GAL. We have a lawyer who's the petitioner. Tell us a little bit about legal fees. Who pays for the fees? Who pays for all this stuff?
Well, typically the petitioner hires the attorney, and they would pay the attorney. However, there is a specific provision in the code section that if the petition is filed in good faith and a guardian and conservator is appointed, the estate of the respondent would reimburse the petitioner, would pay the GAL fees. And in fact, even if the petition is not ultimately successful, if it was filed in good faith, it's still possible for the court to say, yes, the respondent's estate would pay those fees.
Sure. And that would also include if in the process the respondent asked to have their own attorney, then they would be responsible for paying for that attorney as well.
Yeah, so unfortunately, again, not having these documents that we talked about at the beginning can really result in a great increase in the cost of obtaining that sort of control and ability to handle these matters for the individual.
Absolutely. Let's talk about the reporting requirements after you've been appointed. We talked about a couple of documents here. Barbara, tell about the types of things you have to do and report to the Department of Social Services.
Right. For a guardianship, the initial period is a 4-month reporting period. You have a little bit longer to file your report. There's a $5 fee. It's included, the instructions include the address where you send that report in. Then it's 12 months thereafter, a 12-month reporting period thereafter. And that starts from, the first 4-month report starts from the date you actually qualify, not the date that the judge signs the order.
Okay, okay. And then you have to do that every 12 months
Every
thereafter.
12 months thereafter,
So keep it
yes.
until the conservatorship ends. Now, in addition, we have a very detailed reporting requirements because you're handling somebody's money as a conservator. You're being bonded in order to protect that money for the respondent. Tell me, what are the things we have to do with the Commissioner of Accounts as far as keeping him informed about what we're doing?
Well, as Barbara mentioned, there's this reporting requirement with the conservatorship and the Commissioner of Accounts. We're having to provide the breakdown of all of the receipts in and expenses out with actual invoices and bank statements and canceled checks, which sometimes, you can't get the hard copies anymore. There's either a microfiche copy or, but our commissioner now, or at least one of them, we have 2 in Prince William County, is wanting the original bank statements. Copies are not.
Really? Okay.
Copies are not sufficient.
Interesting.
So that's important to know. So it's documentation, documentation, documentation. Keep your receipts, save everything, so that you can show the paper trail, be organized.
Okay. And of course, obviously you want to have all the money in an account that's in the name of the person you're taking care of. It's not supposed to be a joint checking account.
Correct.
between you
It's
and-
supposed to be a fiduciary, what we would call a fiduciary account.
Yes.
And sometimes the banks aren't entirely up on that either, so it's important to do that right when you go to the bank.
So it's important to start out correctly. Well, that's a good thing to know. And again, the will, the inventory forms and accounting forms, all those are going to be posted on the Probate Nation website as well. Let's talk about some common problems and pitfalls. Tell me some of the common things that people trip over, okay, in undertaking to make a request to be appointed a conservator or guardian.
Well, Richard, if you're trying to navigate this process on your own, you're likely to make some mistakes. You're likely to encounter many problems and pitfalls, from a petition that doesn't include required information, to a notice of hearing that might be defective, to an order that doesn't have necessary provisions. So finding an attorney that can help you should make an experienced attorney that can help you should make the process a lot less stressful. And also, you may encounter some obstacles if you haven't spoken with family members, particularly if you're pursuing a guardianship or a conservatorship for a parent, as an example. If you haven't spoken to your siblings about this matter ahead of time, you may encounter some obstacles. You won't know who might be willing to serve as a standby guardian, as an example, or whether they will be supportive of your efforts.
Okay. Beth, how about any observations from your perspective as far as pitfalls or things like that?
Well, as you mentioned in the beginning, and we've talked about a little bit throughout, is the bonding issue.
Yes.
And making sure that you actually can qualify for the bond. And again, back in the day, as they say, Richard, used to be pretty easy, right? The insurance companies would just write the bond, and that's not so true anymore. And they make the person asking for the bond provide their financial information. They now want to see, what do you own, what is your income, that sort of thing. So even somebody that doesn't have a credit problem may not have sufficient income or assets to qualify for a bond. And then, of course, if they've filed bankruptcy or been convicted of a felony, they're not going to qualify for a bond. So
that can be a big hole to trip over if they don't look at that right at the very beginning.
Exactly. If you wait till the end to find out you don't qualify for a bond, then you've wasted some time.
Wasted some time and some money. Well, boy, there's a lot of moving parts here. There's the bond part. There's these documents we should execute in advance. If we haven't done that, then we have to work through the petition and go through the court proceedings. And even after we get appointed by the probate office, we have more work to do. Which it's wonderful that folks are willing to take this on. You guys are very experienced. Why don't you just take a minute to sum up, from your perspectives, the different things that people ought to keep an eye on as they think about undertaking to pursue a guardianship or conservatorship for their adult parent.
First and foremost, plan ahead by encouraging your loved ones to execute the documents that we talked about earlier, the powers of attorney and other documents, while they still have capacity to do so. And remember that these proceedings are truly legal proceedings of last resort. If you have a loved one and they do not have the capacity to sign these documents, then work together with an attorney to provide all the information that is requested as soon as possible in a timely manner, and also be flexible with scheduling your meeting with the guardian ad litem attorney, because these things will just make the process proceed a lot more efficiently for you.
That's good advice. How about yourself? Do you have any suggestions, Beth?
Well, I would say if you can get everybody in the family on the same page, and if there are more than one adult child, it's a good idea not to surprise anybody with, guess what? I filed for guardianship and conservatorship for mom and dad and never mentioned it to anybody first. So hopefully the family dynamic will allow for some family discussion, joint decisions about that kind of thing, because sometimes they can go awry unintentionally by not having that kind of discussion, if possible. Sometimes it doesn't work that way, but hopefully it will.
I would definitely underscore, sort of the building a consensus among the family early on, so that no one is surprised and think you're trying to gain some sort of control over mom or dad's assets. And certainly, I think, the thing we have seen, and I think you emphasize this, Barbara, is that there's a lot of moving parts, and though it may seem relatively straightforward, that someone with some experience, especially in the jurisdiction where you're petitioning the court, can be extraordinarily helpful in making that process go much more smoothly. So those are both good suggestions. I want to take this time to thank both of you for taking the time to talk to us today. This has just been an extraordinarily helpful, conversation, and a lot of valuable information, and you guys have done a great public service for, our viewers and for all the folks in Prince William County. So again, thank you very much for coming to visit with us.
Thank you for having us, Richard.
It's been my pleasure. Our population continues to get older every day. And with the passing of time, many of our elderly are no longer able to make good medical and financial decisions for themselves. There are several recommended legal documents that could be executed in advance to allow someone you select to make decisions for you when that time comes. But many of those senior citizens have not taken advantage of that planning opportunity. And as a result, a living probate called a conservatorship and a guardianship may be necessary. As the discussion with our guests illustrates, there is much that will need to be considered and done to file and successfully prosecute a petition for a conservatorship and guardianship, beginning with working with the family, to preparing and filing the petition, to dealing with the court-appointed guardian ad litem, to preparation of an appropriate court order and a court hearing where that order is signed, to the probate office qualification after the hearing, and much more. This can and often is a complicated process, and certainly it's not a fill-in-the-blank kind of legal proceeding. We strongly recommend that you seek the advice and assistance of an attorney who has experience with adult conservatorships and guardianships, should you need to embark on the living probate train ride. This brings us to the conclusion of our show today on adult conservatorship and guardianship in Prince William County, Part 1. I hope it was informative, and remember that replays of the show can be viewed on the Probate Nation website. On behalf of myself and the Probate Nation, thank you for visiting with us.